they are taken care of there. So once the plaint is filed, the reliefs are sought here. So order 7 is taken care of. Then the next step in the Code of Civil Procedure, what tells you that here, the writ of summons should be served within a period of 15 days upon the defendant. So you must take these steps and prepare the writ of summons. What is a writ of summons? Is defined under the provisions of Order 5 of the Code of Civil Procedure. How the summoning service is to be effected, either through the bailiff of the court or the registered AD of the court and personal services. Now, once the service is effected, then comes next the role of Order 8 of the Code of Civil Procedure, where the defendant is required to file written statement within a period of firstly 30 days. The first option is given 30 days. Extended time is 50 days. Further extended time 90 days. If within 90 days time you do not file your written statement, court may not take on record your written statement later on, and decree will be passed against you ex parte. Mean without any problem. You must immediately advise your client to start preparing your written statement. Sometimes many advocates waste their time by writing letters. You give me inspection, the documents. Unless and until it is given, I cannot file. You can wait for the document. Subsequently, you file the written statement after taking instruction from your client, denying the written statement, taking up the plea of jurisdiction. So, what are the pleas which are available to a defendant? Number one, the defendant can take up the plea that the court has no jurisdiction. The defendant can take up the plea that the suit is barred by limitation. Okay. The defendant can take up the plea that here there is no cause of action. When there is no cause of action, the suit is liable to be dismissed. Order 7, Rule 11 CPC empowers the plaintiff to take out application for rejection of the plaint at any stage. Okay. This is the remedy available to the defendant after receiving the writ of summons to file a detailed written statement. Now, once the written statement is filed, then the role of the court comes into play to read the plain written statement and documents and record to frame the issues. They are taken care of under Order 14 of the Code of Civil Procedure. Please note that. Under the Code of Civil Procedure, Order 14 के अंदर, the court frames the issues. Whether the plaintiff prove that he has any right title interests, whether the defendant prove that the defendant is a trespasser, whether the defendant state that whether the defendants submit that they claim that the suit is barred by limitation. So these are rival questions. The court will frame the issues for determination. They are framed under Order 14. Please note that here. But if the defendant or any of the parties want to take up the plea that the court has, there's a plenary objection to the maintainability, can make an application that here to the court, the issue of jurisdiction goes to the root of the matter, may be decided as a preliminary issue. Earlier Section 9A, which is now abolished. Now under Order 14, Rule 2 CPC, the court can decide that. Okay. Now in the event of the defendant having not filed the written statement in time, a decree has been passed, then there's a different remedy. You can come to the court of law for setting aside the decree. Now, once the issues are framed under the provisions of Order 14, then the next stage under the Code of Civil Procedure is the court normally direct the parties to take inspection of the document, file interrogatories, question answers, take inspection of the original record so that one party is not taken by surprise to the various contention. So these are contained under the provisions of Order 11 and Order 13 of the Code of Civil Procedure. They are called pre-trial steps to be taken by the court of law in the Code of Civil Procedure Code. Okay. When it is 7 o'clock, you inform me, we'll stop it. Then we'll, after a break of 3 minutes or 5 minutes, we'll take the CRP. Then I will continue till the stage of a trial. Then I will stop it here for today's lecture. Then the next lecture will continue further. Now, once the issues are framed, the directions are given by the court to exchange documents, to take interrogatories under Order 11, Order 13 CPC. When it is completed, then the stage will come for leading evidence of the parties. The role will come of Order 18 of the Code of Civil Procedure. Under Order 18, right to begin, the plaintiff filed a suit for a declaration that the defendant is a rank trespasser, he is liable to be evicted. And plaintiff is entitled to the suit. A decree may be granted. Defendant will file a suit, will come out with a contention. I am not a trespasser. I am into possession, adverse possession, for more than 15, 20 years. Under the provisions of Limitation Act by virtue of Section 27, a suit which is not filed within 12 years, suit is barred by limitation. So these are the contentions which are raised by both the parties. Then the next step will be leading evidence under Order 18, Rule 4. Now CPC permits. So here the evidence, how evidence is a three type: examination chief, cross-examination, re-examination, re-cross-examination. So role of Evidence Act come into play here. Okay, examination chief under 137 of the Evidence Act. Examination chief is your evidence of the plaintiff. That is required to be filed by affidavit under Order 18, Rule 4A CPC now. Now, once the affidavit is filed along with the list of documents, you give the copy to the other side. The court will say that the next step will be the affidavit, the other side to give a say on the list of documents, whether what documents are admitting, what not admitting. So role of the Evidence Act will come into play here from section 135 to 136. These are called admissibility of document. Okay, admissibility of document के बाद, then the defendant has a right of cross-examination. Right of cross-examination under the Evidence Act, now under the BSA Act. See, Evidence Act ki theory is very clean. Your examination chief should be confined to the pleadings and the documents placed on record. Whereas the cross-examiner can travel beyond the pleading because he can impeach your credibility. He may take up the plea that the documents which are produced are sham, colorable, bogus. The evidence is not reliable. He may impeach your credibility. He may say that the document which is produced on record is a sham, bogus document. And you are in the habit of producing bogus documents. So cross-examination, the court will pass order with regard to admissibility under section 136 of the Evidence Act, now under the BSA, some new section, we'll quote it. Uske baad, then cross-examination is over. If any point is left out and new document is come, you have a right to take the liberty or leave of the court, seek permission to lead evidence in re-examination. I would like to re-examine the plaintiff because some new documents are come on record. For example, at the time when the suit was filed, probate was not obtained. Now, the Bombay High Court or District Court has granted a probate, which I would like to produce before the court to substantiate the contention that I am the owner of the property. So that can come at the time of examination. Chief probate was not ready, so the court will permit it under the provisions of 138. There is a provision. The permission can be sought for a clarification or additional evidence can be done. Once that document is come on record by virtue of a re-examination, other side will be given an opportunity to re-cross examine you. That is called re-examination of the witnesses. So that way, the list of witnesses is required to be given by both the parties under Order 16, Rule 1 CPC. Please note that. A list of witnesses, so that you are not taken by surprise. You have a right to make inquiries about who are the persons sought to be examined, to know their demeanor, whether they are genuine person or bogus person. Both the parties are under obligation. In the city of Bombay, I have seen practice is that here district court people are more careful in filing the list of documents. Now the courts in Bombay also are becoming more and more vigilant, directing the parties file the list of documents. Formally such a rule. But you have a right to examine a new witness without such list being added if the witness is necessary for your case. That is Order 16 के अंदर provision है. Okay, please note that. So once this procedure is done, then the other side defendant has a right to lead evidence. Yeah, other side has a right to. Similar provisions will come into play. List of document, examination chief, cross-examination, re-examination. Okay, under the Evidence Act, both the parties, you have to lead evidence cross-examination subject to the rules and regulation, and the court has power to ask question under 165, irrespective of whether the question is relevant or irrelevant. Trial court's powers are very vast. Now, once that is done, when the trial is closed, when both the parties have finished evidence, they have to give a pursuant document called, we are closing the evidence, the matter is set for arguments. Now, provisions of Order 18, right to begin, read with Order 20 will come into play. You also have a right to file written arguments. So, the party normally who close the evidence last will have a right to begin first. These are the rules framed, the inbuilt rules pursuant to various Supreme Court and High Court judgment. It may not be there in CPC or Evidence Act. Who should begin first? Argument. The person who closes the evidence last begins it. Okay, then the matter is set down. The post passes a judgment under the provisions of Order 20 of the Code of Civil Procedure. If the judgment goes against you, make an application immediately that the operation of the order may kindly be stayed to enable you to go in appeal. Okay, that provision is there under Order 41, Rule 5(2) made. So at the moment today, we stop the Civil Procedure Court, and after 5 minutes break, we'll take the CRPC. Then next week again, we'll continue the CPC lectures. Okay, please take a break. Is it okay? Have you understood, all of you? Anybody has any queries so far?
No, sir.
No queries. Okay. Any queries you may ask me after 5 minutes. Now I will take briefly after 10 minutes the BNSS, the CRPC, new CRPC, which will be useful for the students and also young student. Okay. For 5-10 minutes.